Well, as well known, yesterday, a judge here in California ripped away from the people what they had voted on when they affirmed 14 words from Proposition 8. Simply says only marriage between a man and woman is valid and recognized in the state of California. In making that decision, the judge really took away from us more than marriage, more than the definition of marriage. He took away from us something that's very valued in American culture, and that's the consent of the governed. This issue was vetted. It was vetted enormously. Each side spent about $40 million. So after an $80 million campaign, probably the most expensive proposition of any type election in any state in America, after all that process and after working our way through all the issues, California voters decided not once but twice on the same exact wording, first in Proposition 22 back in the year 2000, then in Proposition 8 in the year 2008. But a judge, one judge, Von Walker, who, by the way, was outed for his own sexual orientation by a public newspaper in the midst of the trial, did not recuse himself from the trial over that issue, he has decided that Californians are irrational. He says that it's without reason that we would do this. It's without any kind of reason. We had no support for it. And he goes on to claim that it was only bigotry that would cause people to come to the conclusion that marriage is one man, one woman, as has been affirmed by every culture, pre-Christian cultures, anti-Christian cultures, Christian cultures, for the course of the last 5,000 years, who have come to the conclusion that one man, one woman marriage is the model. Why is that? Because it simply works. And natural law indicates the same thing. By virtue of the fact that the man contributes a sperm and a woman contributes an egg, they are in the best posture as natural mother and father, or a facsimile thereof, to raise children and produce, in turn, a healthy society. But not according to Judge Von Walker, who, riding over roughshod over the will of the voters in the state of California, some 7 million voters who said yes to Proposition 8, on his one single ruling, he has thrown it out. Not only for the state of California, but based upon the U.S. Constitution, he's throwing it out effectively for every other state that may have similar type of laws. We would wish the judge would have looked at the beginning words of the Constitution, which says, "We the people." There's a reason why it does not start with the words, "I the judge." Our forefathers were very aware of the dangerous power of a judiciary. Thomas Jefferson warned us about that. That's one of the reasons some of our forefathers actually fled England to get away from an imperialistic judiciary. So some might ask, what's the big deal? What difference does it make when some homosexuals get married? How does that impact my marriage anyway? Well, the fact is, it impacts it a great deal. I was involved in a debate in Channel 35 in Los Angeles back in 2008. And in the course of that debate, the question was asked by the moderator, can the two concepts, can the two constructs function side by side? That is, homosexual marriage and heterosexual marriage. Before I had a chance to answer, the well-known atheist attorney, Eddie Tabash, responded quickly with no. No, they cannot coexist. One wins and the other one loses. And there's truth to what he said. And here's the reason. That once the government has a vested interest in affirming and protecting so-called gay marriage, once that occurs, three things are set in motion, three losses. There's a loss of personal freedoms. There's a loss of parental rights. There's a loss of religious liberties. The reason we know this is we can look at states in the United States that have had gay marriage for a period of time, or we can go specifically to certain countries in Europe that have had it for the last decade or so. What we find is tremendous loss of personal freedoms. Let me give an example right here in the city I live, in San Diego. Two medical doctors, for example, had a biblical conviction, a Christian conviction, that they would not artificially inseminate a woman unless she had a husband. When a woman came to them and asked for the procedure, and they declined the same way they always had, they indicated there were other doctors who would do the procedure for them, and they referred her on to them. But that wasn't good enough for her. For you see, she was a lesbian, and she was convinced that it was some kind of animus against her. She took them to court. She won. It was going to cost $1 million for those two doctors to take their case all the way to the U.S. Supreme Court. There was a crushing of personal freedoms. Or the 25-year-old photographer, Albuquerque, New Mexico, who said, no, I will not be able to take a video of your lesbian celebration for religious convictions, but others will. That wasn't good enough. They wanted to force her to do it. And so the state stepped in, and that court case is still ongoing. We could give hundreds of examples such as that. The second area is loss of parental rights. Dave and Tanya Parker in Lexington, Massachusetts, after Massachusetts had gay marriage legally for a period of time, they were informed they could not opt their child out of the discussions about homosexuality. In fact, the rationale of the state went like this. No, you can't take your child out. And they said, yes, according to the laws of Massachusetts, if someone is teaching about sexuality, a parent has the right to opt their child out. They said, no, this is not sexuality, it's homosexuality. Therefore, you cannot opt your child out. Besides that, it's state law now. It's state accepted. It's state mandated. Therefore, you cannot opt your child out, and the school would not cooperate with them. The judge would not make the teachers come and testify as to what they were teaching on the topic, and he said to the Parker family, you need to segregate, that's the word he used, by the way, you need to segregate yourself from the school system. In other words, fine, the Parkers could pay taxes to support the school, but the Parkers could not opt out their second grader from discussions on sexuality, or specifically in this case, homosexuality. That's the kind of loss of parental rights that occurs when the government gets involved in affirming and protecting so-called same-sex marriage. Now, in addition to that, there's a loss of religious freedoms. Åke Green is a Swedish pastor. He preached on Romans chapter 1, specifically about the topic of homosexuality. And he was sentenced to a month in prison, went through an elongated trial involving 3 levels of the court system there in Sweden. Coming much closer to home in Canada, one pastor, a young pastor, wrote an article for an editorial in a newspaper, or responded to an editorial, and he ended up in a court case that lasted a long time and cost him a tremendous amount of money simply because he articulated the issue that homosexuality is an unacceptable practice biblically. And other cases such as that in Canada, or coming much closer to home into the U.S., the Ocean Grove Camp Meeting Association, a beautiful site, a church and camp meeting, an independent holiness Methodist camp right on the Atlantic Ocean in the town of Ocean Grove, New Jersey. 2 lesbians came and said, we want an affirmation ceremony. They said, no, we don't do that. We're a church. That one is still under litigation in the state of New Jersey. The day will come. It won't come immediately, but the day will come in any state where the government has a vested interest in defending, affirming, and protecting gay marriage. The day will come when churches will be forced to hire active gay persons to be on their staff, when pastors will be forced to perform gay weddings, or they'll lose their 501(c) status and consequently, in many cases, lose their building. That day will come eventually. Not immediately, but eventually. There are what some have called unintended consequences of gay marriage affirmation. Unintended or not, they still happen just the same. Some may say, well, you're just saying that because you're a preacher and you care about the Bible. Well, I am a Christian. I'm a follower of Jesus, and every follower of Jesus that's serious about his faith does follow the Scriptures, and I'm unabashed about that. Churches that follow the Scriptures are authentic Christianity. Churches that don't, that defy the Scripture, they're more into religianity rather than they are Christianity. However, for those who are followers of Jesus, they will find the Scripture is crystal clear, contrary to what the revisionists have been doing the last 40 years with 6 or 7 biblical texts and rewriting them over. The Scripture is crystal clear in terms of the model of one man, one woman marriage. But some people don't care about the Bible, so I have to respect that fact. We're in a pluralistic culture. Some people don't want to follow the Bible, and we have that privilege, do we not? That being the case, and we appeal to sociological data, the social science overwhelmingly affirms that the best chance a child has is when it has its mother and father taking care of it. In fact, the number one contributing significant factor in the life of a young boy, for example, of him not getting in trouble with the law is when a father is present. So let me ask you a question. If you have a home that's got 2 dads, or you have a home that's got 2 moms, which one is unimportant? Is it the mom that's unimportant, or is it the dad that's unimportant? And if you make the case that legally the judge says that we have to, under equal protection clause of the Constitution, have to allow anybody to get married, to who anybody they want, then what is to keep us? What is to keep us from saying 3 people who want to get married, 5 people who want to get married, 2 men, 5 women? What's going to keep you from that if we have said, as the judge says on page 115 of the decision, a marriage is simply the union of equals. How many? Historically, it's been one man, one woman. That's gender specific and it's numeric specific. But now the judge has done away with any notion of gender specificity, and when he says marriage is simply the union of equals, as he says, therefore, why can't three? Why can't four? Polygamy groups are excited that Judge Von Walker has devastated and destroyed the most fundamental unit of society, marriage being one man, one woman. Where are we now in our journey? Well, we start through the court system, as everyone knows. The Ninth Circuit Court, first of all, and eventually to the Supreme Court. We will pray that there are people with enough moral compass in them that they actually will authentically stand for truth of what is best for our society and what is best for the children and what will preserve this great land we call America.